Will you review what the Supreme Court is being asked to consider about police and their use of deadly force? Okay. Well, there's qualified immunity, sovereign immunity, and absolute immunity. Okay. What they're talking about is qualified immunity. And the Supreme Court just this month has agreed to hear a case that I think has been going the wrong direction for a long time. Up until, I guess I should say, this is going to affect how the United States goes forward in its police action if it takes the spin that I think it might. The United States, up until 1967, never had this thing called, qualified immunity. Now, I'm not going to talk about sovereign immunity or absolute immunity. That's a whole, these are kind of scaled kind of things, building blocks or that have got a lot of ramifications. It's a complicated subject, but qualified immunity is something that is applied to, generally speaking, to police officers. Before 1967, when the Supreme Court made a ruling, there wasn't any such animal in the United States. Police officers worked, and they knew that if they stepped out of line, they were liable to be held responsible. They didn't have a get out of jail free pass. And during the 1967 civil rights disruptions, the Supreme Court ruled that police should be protected in the performance of their duty. Now, most of us will say, golly, I thought that's the way it always was. No, it should be, and we ought to do it that way. But since 2005, particularly, there's been an egregious climb in the number of deadly force issues that are happening with police officers involved. And it's kind of a shoot first and ask questions later kind of thing. I know. There's a lot of people that are going to get steamed about this. But before 1967, there was not that. Police officers served. Police officers realized, hey, you step over the line, there's going to be a problem. And so we didn't have a lot of, I know I was stationed in the Deep South then too, and sometimes some of the officers got a little bit enthusiastic in their enforcement of law. So there are exceptions, unquestionably, about that. But it was kind of a thing where they thought, we need to protect these people so they're not looking over their shoulder all the time and they don't end up getting killed. But now, over the years, there's been at least, I'm thinking, 15 major Supreme Court decisions that have strengthened this sovereign immunity kind of thing to the officer's point that almost never can you get a conviction for an egregious violation that clearly stepped over the line. Now, I'll just give you an example. One of the ones that comes to mind happened in 2018. So it was only 6 years ago. But here's how it's kind of come to the point that if you did something that was clearly stated in law that you can't do it, well, okay, we'll hold you accountable. But what happened in 2018, this was in Tennessee, there was an individual that was a prisoner of the police. He was surrendered and he was sitting on his behind on the ground. His hands were in the air. And the police sicked their police dog on him. That seems like that'd be an egregious violation. Well, the police officers were exonerated because there was not a specific example in the law that says you can't sick your dog on somebody that's surrendered with their hands in the air, sitting on the ground. Now, there was some that said, oh, if the guy's laying on the ground, face down, and you sick the dog on him, that ain't right. See, if that had happened, it would have been okay the police would have actually been held responsible for it. And so, because there wasn't a specific example of a law or court case that prohibited your action, the likelihood of you being found at fault or slim and none. And again, it's gone way beyond this trying to protect a good faith effort that somebody in the heat of the moment made a mistake. Now, this case that's just been accepted by the Supreme Court this month, October of 2024, is being brought by a mom whose son was killed by a police officer after he failed to pay a toll on the highway. There was an ensuing chase. The officer ended up shooting him down. Okay, now there's a lot more details than that. But the reason that the Supreme Court, and there's probably more to it than what has been publicly stated, but the Supreme Court is taking it on the face value of this, that see, up to this point, most everything that's been looked at has been looked at the actual moment that it happened. Did you think you were in danger? Was some guy swinging a hammer at you? Yes. Okay, you pulled the trigger. All right, you're fine. Okay, now that's a pretty cut and dried, it would seem, kind of issue. But what the Supreme Court has agreed to hear in this particular case is, did the officer do anything in advance of that time that precipitated the death warrant? Okay, so they're going to look at the lead up time. You know, could the officer have done something different, and it was maybe an execution rather than a clear cut, the way it's been shown other times. I'm doing a fairly poor job of explaining this, but there are very, very, very few attorneys, and probably in your community, go talk to them, that would take a case where they were trying to pursue some kind of overstep of the law by the police, because the bar is so high and they have so much leeway in it. Again, this didn't exist before 1967, and it's been supported and supported and supported more strongly, to the point that deadly force is almost a sure thing of clearing the police officer nowadays. And somebody, you know, their kid gets killed, they go to an attorney and they say, can, you know, look, my kid was in the front seat of the car, and as he rolled the window down, they shot him. And you're going to have a hard time finding an attorney, because the bar is so high of what you've got to prove to demonstrate that the officer acted outside what this immunity level that they've gained. One thing you might find interesting is that there is not one single federal statute out there that provides this immunity to officers. It's all based upon court cases. Now you might say, are the courts writing the law then? Well, there's an argument that could be made that that's what's happening. The courts actually have strengthened and strengthened and strengthened this to the point that they don't need a federal law, because it's being enforced the way the court said to enforce it. Now, on a local level, there have been some good things and some bad things. At some levels, the bad things have been that the local, you know, the legislatures and the courts and the municipalities and everybody have made laws that track with the strengthening of the immunity of the officers, and so in many local instances, they have created a real strong case that you could never overcome if your kid got killed by deadly force, because it follows with the federal court cases. But I'm thinking there's probably 3 states, there may be more now, but I think New York, I think Colorado, I think New Mexico, those are 3 that come to mind. I've said, no, there ain't no more of this in our local jurisdictions. But they've been careful to walk back the idea that it could be, you know, imposed upon the federal government. But the fact is, the federal government doesn't have a law about it. All they've got is court cases. So you might say, you know, this is a Republican Democrat thing, and it kind of is. And there's efforts in the Senate right now by the Democrats to walk back this immunity level. The Republicans are against it largely. You know, we're the law and order guys, they say to themselves, and the Democrats are the anarchy guys, or whatever they say to themselves. But what is interesting to me is that Clarence Thomas, everybody'd say, man, that dude's conservative Supreme Court justice. And Sotomayor, man, she's a liberal Supreme Court justice. They're both kind of on the same side of this. Both of them are saying that this has been wandering in the wrong direction for too long. And really everybody has a responsibility to take responsibility. You look and see, for example, just in the Declaration of Independence, there are 27 offenses of the king that are enumerated, you know. It comes way after the we hold these truths self-evident, blah, blah, blah. And then it goes into 27 offenses of the king. They're very specific. And you know, up at that point, the king could do no wrong. The king's word was the law and everything else like that. And Jefferson and those guys that wrote it with him were pretty pointed. They said, no, everybody's responsible for their actions. And we're not going to give the king a pass. And this was pretty pointed to England. This was pretty ground shaking. And so, and then the American founding fathers in the Constitution, they wrote in the Constitution. It's called impeachment. No, the president can't just do whatever he darn well pleases. There's checks and balances. Congress can have a way of cleaning out the Congress if there's enough egregious violation. There's ways to push back. Supreme Court justices could be removed if we were courageous enough to take the steps needful to do impeachment. But the fact of the matter is, the President of the United States even is not immune. And if you get the appropriate way, you get the indictment, the articles of impeachment brought forth by the House, goes to the Senate, it gets tried, the Supreme Court Chief Justice presides. If 2/3 vote that, yep, that person is out of office, yep, that person is out of office, and then they can be taken to criminal court if it's appropriate for whatever action they did. So nobody gets a pass. And in essence, what's been happening in recent decades is that the police officers are almost untouchable. Again, I can see the point that you know, we need them to serve, but they served before 1967 without this thing, and we probably had fewer police officer caused deaths than we have now. So Sotomayor and Thomas are kind of on the same page with this. So to me, it's going to be very interesting to see if they kind of walk back and they put some principles behind it and recognize that they cannot be anything more than a court, that they can't write the law. So it's going to be interesting to see how they solve this issue. But there's people on, I think you could say, groups that are normally you would say are very much in opposition to each other, that say that we need to do something differently than what we're doing now. And the fact that the Supreme Court has said, we're going to look at this case and we'll give you a decision in the coming year, that's a major step forward, and we'll just have to see how that turns out.